I'm sure Cole introduced us already, but and y'all probably met John in here a bunch of times. I know a lot of y'all in the room. My name is Jared Miguez. I'm one of the co-founders of the Arena Collective. We are a law firm and title company, and this is my partner, John Stevens. We have a law firm and a title company under the collective, and the law firm is run by our partner, Becky. There's a really pretty picture of her on my computer right now. I would show you who Becky was, but the presentation not working on the PowerPoint.
Time.
But John runs our title company, and so we take pride in dealing with the most complicated real estate situations. In the past, there's some things that we didn't want to touch because they were taking a lot of time. And when we moved to our new firm, we set our mind up that we weren't going to tell anybody no matter what the situation was. And so, all the way from filing for partition whenever two co-owners can't get along to doing tax title or, subject to transactions, whatever the hottest thing is, we're going to take it on full steam ahead, and we're going to figure out a process for you guys so that y'all can do the work and have somebody that y'all can rely on. Sometimes things take longer than we hope, and we try to be upfront about that as upfront about that as possible and as best we can. And some things happen, and we had something happen recently that we didn't expect on a subject to deal, which I'm happy to give y'all some insight on that, just to give y'all a heads up about what you need to be paying attention to. But today, and we asked Cole to kind of give this presentation because we find that real estate agents on the residential side or on the commercial investment side have a hard time working with it, or don't have great expectations with their title company, or don't discuss and communicate what the expectations should be. And so I wanted to go through some things today with you guys that would allow you to work best with your title company so that you can know whenever there's a problem, you can help them solve the problem, which is helpful with a lot of the best investors we have, will help us solve a lot of problems as they come up in the process, and hopefully avoid things that can cause frustration with an end buyer or a seller that is trying to get out of a bad situation. And so today we're going to go through some best practices to work with your title company. Anything to add?
I will only add this. Pardon me, I do have to leave in about 20 minutes because my wife has to go. Her sister's in the hospital, so I'm going to go get the kids because they're still legally mine, partially. So I'm in charge of those things. But anyway, to just what he said, I mean, it's all about communication, right? And that's what we preach. Good communications sets the right expectation, right? And then therefore we can all be on the same page. And that includes situations where an unexpected thing arises, right? In which case we got to triage it and communicate well about it so that no one feels like they're being left in the dark. And so that's just like the biggest pain point that we preach week in, week out to our team in terms of how are we going to represent what a good closing is supposed to be, and it starts with good communications, okay?
Yeah.
So that's what I would add there, and I know he's going to get into the meat of that.
Yeah. So we're going to go over several different steps, right? And so just if you want to get a highlight of what the different steps we're going to go over, we call it pre-order, new order, intake, contract drafting, title issue and curative. And then we have some contract negotiations, pre-closing and closing. All right, and so if you look at our workflow within our system, a lot of these are the steps that we follow whenever we're trying to settle a real estate transaction. And so John spends hours and hours and hours of time refining our system, refining our communication tools, figuring out ways to help you guys work more efficiently with us. We work with a very big wholesale investment group out of New Orleans that sends us 8 to 10 deals a week, from cash deals to assignments to subject to, where they're either wholesaling it or take them down. And we have built a system with them that they can help us at different parts of this process, and we can do things for them that they can run as fast as they need to run, and we're not going to be the one that slows them down. And that looks like having a front-end meeting on every file that comes in. They have our intake form whenever they're meeting with their client so that we don't have to then follow up with these people that are hard to get in touch with. We have a weekly meeting with them to review every file they have in the system so they know where we're at and they can help us solve problems. And then we have a system on closing deals for them so they don't have to be at every closing necessarily.
And on that point, it's good, it's best practice. We have a weekly file review of every file that we have active, right? To make sure that we've got our curative, our processors all in that meeting, making sure that what's the next action item, if any, right? And we always want to leave every file with an action item. And kind of what he noted, it is very simple to get a custom intake link, right? And because we know it's boots on the ground, right? I mean, when y'all are out there dealing with sellers and negotiating, time is of the essence, right? You've got a good conversation going, as much information that can be onboarded as possible, and to the extent that we're making an agreement and working on a contract, right? That's going to be as advantageous as possible. So it's easy to quick intake link. We've got QR codes for those. So literally, if you have it and you just scan it on your phone, you can be standing right next to a seller, right? Capture their information. It will be automatically submitted. There's just technology is too, ubiquitous and too easy these days to disregard those simple shortcuts.
And this is not necessarily a sales opportunity for us. Y'all should be trying to interview title companies that are willing to do these things. So I don't know if y'all are all in the North Shore, if y'all have Mississippi work or in New Orleans and y'all have a go-to title company, but these kind of conversations y'all should be having with them to figure out how y'all can build a system around you to be able to do your practice at the highest level. So for the pre-order process, one of the things that we talk to a lot with our wholesalers and our real estate investors is that we will pre-screen a property for you before you even meet with the client, okay? Now, I tell everybody this. If you send us 20 files to pre-screen and you close one a month, we're going to tell you that you got to be more particular about what you want us to pre-screen, because we just can't be using our resources to run title on a whole bunch of properties that aren't going to close. But one of the biggest things that a pre-screen will do is it allows you to know who all is on title. You'll walk into a room with a seller who says, yeah, I inherited this property from my mom, and don't tell you that the sister Susie they haven't seen in 7 years that lives in California also is on title and we find that out as we get through the abstract, and that the succession shows to people inherited it. And so that's one big thing that a pre-screen will do for you. And we'll run a full title search on a pre-screen, full 30 years if we need to, and we'll send you the information about what's on title. And knowing who all the sellers are is a huge deal. The second thing is, and this has happened a lot recently, is that you walk into a room with a seller and you say, what is the condition of title? Oh, well, I borrowed some money from a bank to buy this house in 2020, and I have a 3% interest rate. Well, that's great. Do you have any other thing? Anything else on title? Oh, no, we don't have anything else going on. Well, you get a contract on that, and we find that during the abstract period, 7-8 days later, that they have a HUD second during a forbearance. That's going to take all the money that they deferred during COVID and tack it on the back end, and it's easily determinable or seen if you just do a title search, because HUD files a second mortgage and there's two mortgages you're going to have to deal with. We can let you know that before you even walk in the room with somebody, whenever you're negotiating that, to know that they're going to have to get a second payoff.
And those can be tricky, those HUD partial claims mortgages. Our underwriting counsel at Fidelity and First American are like, yeah, they kind of wreak havoc in this world because they create, an obstacle in the sense of it's another payoff, and it's not necessarily always the easiest payoff to get. Sometimes it can be. It just kind of depends on exactly who it's being administered through. But knowing that it exists, period, yeah. Right, is information that's going to be vital to be able to, navigate from the first step, towards a clear closing. And a lot of people don't really even know. I mean, it's not like they're trying to pull wool over our eyes. And so, I'm sure there are times when that might be the case, but a lot of times they don't know. They might just say, well, yeah, I did sign some paperwork. I had no idea really what that meant.
I didn't know. The story we get most times, I didn't know I had to pay that back.
Right.
It's not free
money.
They
thought it was pretty much forgiven, right? Exactly. And so learning, us being able to do that pre-screen, which is a complimentary service, right? Again, just don't throw every,
every shitty deal.
Every assessment, yeah. Every assessment in St. Tammany to us. But yeah, I mean, that's what it's about. We want to arm y'all with the information you need to go negotiate a good deal, right? And underwrite it well.
Yeah. So is there like a portal for that? Or how does
the only thing, if you give us a property address, we will then pull the assessment and we'll run title on that property.
Yeah.
And we have a pre-order set of files and file numbers so that we'll open it as a pre-order, run title on it, save the abstract. So if you actually get it under contract, then we're already a step ahead of the game because we've already ran a 30-year on it. We can just immediately start solving the title problems.
Yeah.
And so we have a system around it, and it works. And we had a couple files recently that we pre-screened months ago, and then they end up coming back to life, and we can move on those pretty fast. Another thing a pre-screen will help you find is that if there's any tax sale interest outstanding. Mm-hmm. And the difference between somebody who lost title at the tax sale 3 years ago and 4 years ago is a significant difference depending on it depends on that will make a difference on who you have to order a payoff through, whether that's through the assessor or the sheriff's office. We have to go directly to this tax buyer that could be anywhere that we've got to go hunt and find, right? And so and a lot of times we can solve that problem by finding the person who paid property taxes for somebody else and it's been over 3 years, and we can negotiate that or at least get a payoff and start the negotiation process. But it's easier to do that ahead of time than trying to squeeze it into a 10, 12-day contract period.
We had that one not long ago where we had to go to this person's house, and like our attorney Kyle went several times, knocked on the door, no answer, and then finally just, he gets the door open, like, it's like the door hadn't been open in 100 years, and this person just kind of pokes through looking at him and, hey, but if that's what it takes to figure out the information that's necessary for tax title and redemptions and stuff like that, we'll go bird dog it.
Yeah.
And that's not it's not a sales pitch. I mean, sometimes the information, you're not going to get it from a company that has a department for payoffs, right? It is a just normal human being living wherever in whatever neighborhood that you've got to go discuss how much money do you need, right? What's the payoff?
Yeah.
So that was a fun one. Yeah.
He got bit by a dog when it's by his house too. I tried to tell him to stop doing that, but he keeps going.
Yeah.
Another thing that a pre-screen will help you determine is knowing who to assign your contracts. We talked about you might find out somebody's not on title, but you could have and this person owned property through an entity and they signed it in their personal name, or somebody owns it through a succession and they got to have the capacity as executor of the estate. Things like that allow you to have more solid contracts if if we look and see who's on title to make sure that you have the right entity actually signing your contracts. And we've had situations where a person did not have all of the heirs sign the contract. So they had some of the heirs that were under a binding obligation and one that wasn't. And the one that wasn't didn't have to show up. And he kind of controlled the narrative and got to take more than his 1/3 interest in the property because he was like, I'm not going to come unless you give me X. And they had to pay him that in order to close the deal. So it's good. Again, pre-screens are super important, and we're happy to do that. And that'll allow your title company to get ahead of some issues before they come across their desk. All right, so the new order process. So after you've identified a property, you know what's going on with title, you've run a pre-screen, and you've got it under contract now, you're going to send that in to us or your title company. There is some things that we recommend that make the new order process easier and more efficient. The one thing that you need to do is you need to reach out to your title company to find out who you should be connecting with whenever you're sending in a new order. Like, we have people who have been working with us for years, and they send it to a random email address that has nothing to do with opening a new order, and it can make files get delayed, and it's super important to know where to send the order to. And another thing that we like people to do, and I've tried to help people understand this, is to include your client on the email to us and introduce your title company to your client. Right? Does anybody have a problem with that? And I'm just curious to know if there's any reason why you wouldn't do that. So you get a property under contract with a seller, and you're going to tell them a random title company is going to reach out to them, and you don't give them a phone number, you don't give them a person's name, you say Arena Title is going to reach out to you. They get a random 985 number, call them. They're probably not going to answer that phone call. But if you put them on an email and you tell them, hey, I just included you on the email with the attorney or with the team, Haley on our team can reach back out to him and say, what's a good time for me to reach out to you? This is my phone number. It just connects the dots a little bit more, and people just totally miss that idea. But like, how often do you just like tell somebody, yeah, they're going to reach out to you sometime in the next couple of days and just hope that somehow they get connected with each other? It seems that it can be more efficient. And one of the things that I have on here is connect us with your client. It's an easy thing to do, and it really helps us bridge the gap. Were you about to say something?
And look, I mean, like, think about it too. 'Cause y'all are the first connection that these people have. We'll have people say, we'll have that. Well, they will have that conversation with the seller, and nonetheless, we call them. They say, "I'm not giving you any information. You got to get it from this person who I trust." Right? They don't know us, so y'all are a lot of ways. They're saving grace in some instances, right? And regardless what the situation is, you're kind of that front line. And that's not to say that anyone's going to advocate responsibilities for intaking or anything like that on y'all, but it does help if as much as you can kind of hold their hand throughout the process in some situations, right, and just just reassure them, lead them to the water. Not everyone likes getting phone calls from a law firm or random, like Jerry was saying, just a random company that's all of a sudden trying to get their Social Security number, right, or the last 4 digits of their Social Security number. And I understand that because I did a seminar with that detective at St. Tammany a few months ago, and just the millions of dollars of people already this year that have been defrauded from just people calling them and asking for information. There is an understandable hesitancy there, so just keep that in mind, and we want to work with y'all and make y'all's system as good as possible and support it as best as we can.
It seems like what I'm hearing y'all saying is that some of these people are in an emotional state.
Yes. Mm-hmm. Yes.
Whether they're
Yes.
angry, PO'd, whatever they are.
Right.
Sad, whatever. Depressed.
Yep.
So knowing that is all the more reason to make this form introduction.
Exactly.
To make them feel like they're part of this arena's part of the team.
Yeah.
Exactly.
You got a rapport with them, and you can vet that or you can endorse that. That's a huge thing. It really is. Yeah.
Third-party endorsement is what we're doing.
Yeah.
Sure.
Yeah.
And another thing, has anybody had any nightmare experiences with any of this stuff what we're talking about, or had any struggles with title companies when it comes to this kind of stuff?
Oh, yeah.
Okay, I was hoping somebody would say yes, otherwise I'm talking for no reason. And so so when we're dealing with some of these people that we get, they're just not easy to communicate with for whatever reason. They're sad because somebody lost a loved one. They're sad because they're going through bankruptcy. They're having a hard time for substance abuse, or they're just genuinely not responsible type of people, and you just generally not responsible. So you have to chase them down a lot. And one of our biggest struggles, our team asks us all the time. Part of the reason why I reach out to Cole is that they're like, "Can you please talk to people and kind of advocate for this and make this a little bit more efficient?" And so it's part of the reason why we're doing this. And one of the biggest pain points that we have is that when we get a file in, just so y'all understand what the title company is doing, if we're trying to order a payoff from a law firm representing a creditor, from a mortgage company that is owed money, from the assessor who has a tax lien on the property, even though we're a law firm and we're a title company and some people know who we are, if we just call and say, "Hey, I need a payoff," they're going to say, "I can't give that to you without authorization." And so we may at some points in time not know what's the condition of title is, whether it's going to be free and clear, whether there's judgment. So we had a hard time gathering their information on the front end. And then we realize that they have 2 judgments and a mortgage. And so we got to go chase them down again to get an authorization form signed so that we have the authority to go speak to the creditor. So I have armed a lot of my real estate investors with an authorization form that we have now vetted and tailored in so many ways to avoid so many problems that we give that to them. And then when they go in, they have our intake form, they have an authorization form, so they give us everything that we need so we don't have to go through the missed calls and following up to get that information. And we can start running on with the files and get them done more efficiently, because speed is a lot of times critical in these deals.
Yeah.
So
that payoff authorization is huge.
It's huge.
Yeah.
And so just so y'all know, I'm not just like saying that we've tailored these documents to really make them solve problems. Like, these are the things that we've done. So at one point we were putting on the page with the signature page all of the different liens that needed to be canceled. But the problem is we would put the ones we knew, we'd run a title search, and we'd find 3 more. So we have to go back and get another one signed. So we replaced all of them on page 1 with "See attached Exhibit A." So we can add everything to Exhibit A we want, right? And then we went in there and we took their Social Security number, put that on page 2, so we can sign it. We get the Social Security number later, if some cases, if we can do that. Their address. So we've tried to avoid every hiccup that we run into with these things, so that we know that we can get it done one time, or y'all can get it done one time. We can get it and we can run.
Yeah, because a lot, it was at first. Once we get the seller's intake, then we'll get the payoff authorization because we'll have the last 4 of their social, right? Or they might tell us what their mortgages are. Well, that caused a delay in the process, right? Because inevitably it takes a little bit of time to get seller information. So now, we've got an abstract examined, but we can't get this person to sign this document. Whatever the case might be, there's a delay there. So now we want to get the payoff authorization executed immediately and supplement that with the information that comes from the title exam, or wherever else that we might derive it with relation to the information that we're trying to get based on that authorization. So it's how quickly can we get these things in the boat, right? and then we'll figure out what we need to do with them as more information comes in.
Even if somebody says, I don't have anything I need, they need to be paid off, we still get it signed, because inevitably something's going to come up that we don't have to go back to that. Has anybody ran into that problem where they don't have, their clients are not getting payoff sufficiently, or they can't get in touch, or you get the title company say, I haven't ordered that payoff, I haven't gotten that payoff back yet, we have to wait a couple more days, we're waiting on a payoff. Like those types of things, what they're saying is that they had a hard time getting in touch with the creditor, or they had a hard time getting the information from the buyer or seller to go and then order the payoff. So this is a step that helps you guys avoid that issue. And when you're meeting with your clients and talking about their situation, and you're getting the contract signed, or you're getting, if you're an agent, you're getting the listing agreement or the buyer rep agreement signed, having this on the side just to say, hey, this is just a CYA for us as a title company, or for us in the title company to make sure we don't run into hiccups. So getting that signed. Something else on here that I want to talk about, and I might have an opinion on this from y'all's end: deposits and damages written into your contract. If I see another $100 deposit written in on a contract, like I'm gonna lose it. Like as a buyer, if I have to give $100 and that's the only thing I have on the table, and if I walk away from that deal, I lose $100. How many buyers do you think are not gonna just get buyer's remorse before closing and just walk away, knowing that they're probably not gonna get sued and their only risk is $100? I can't tell you how many investors send me a contract that says deposit's $100
For their end buyer, particularly.
for their end buyer.
Yeah.
Right? And so, as again, the end buyer on a wholesale deal, that's an assignment where you have an obligation to buy this property as the assigner, as the wholesaler, and then you turn around and assign that, or even maybe sign another contract on a double close with an end buyer. Right? So now that end buyer really has no attachment to that seller, and you have made that buyer attached to that contract for $100. And a lot of the times you don't even put a damage provision in there, to where there's no consequences for that person to walk away. So many contracts have no damage clauses written in there, no way to hold anybody accountable. And then we get called the day before closing or 2 days after closing saying, hey, will you call this person and tell them that they need to come and show up to closing? Like, there's no teeth involved in any of these contracts that you have. So I would say when you're writing a contract, make sure that you put a little bit more teeth in it than what I've been seeing. Put a $1,000 deposit. Make these people have a little more skin in the game, and put some damages provision in there. I mean, the Louisiana buy-sell agreement has a 10% stipulated damages written into the contract. So if somebody breaches that contract, they know that there's some weight behind that. That make sense?
And that definitely protects you as the middleman. Sorry, y'all. I do. You know. Well, I mean, at the end of the day, I would love to keep talking about this, which, you know, my 20-year-old self might be like, why would he be sad about leaving a real estate lawyer thing? But I do have to go. This man knows it. I will say that on that last comment, though, if you need help looking at your contract, because a lot of what we want, understandably, is a succinct contract. We don't want to confuse the heck out of these people, right? There are ways to create succinct, well-vetted, very supportive and protective provisions into a short, abbreviated contract, right? So if anyone's got one that they want to have eyes on, I'm more than happy to look at that type of stuff, okay? And again, that's not like pay us hourly to do that. That is, how can we help each other? Because the goal at the end of the day is to get deals closed.
Do you have
right?
sample contracts that you could?
Yeah, by all means.
Let us.
Yeah, well,
use or look
yeah, y'all can
Yeah.
use them, but just know that everybody has their own tweaks that they want in their contract. So, don't take Pace Morby's contract off the internet and think that that's gonna apply to Louisiana,
Yeah.
right?
Yeah.
And so I did that. So when we post this, Pace will like it and share it on his page, and everybody will see this in the world because he's got 1 million followers.
Yeah.
But I get a lot of Pace Morby contracts, I really do, and they're not very well written in my opinion, and they don't apply in Louisiana a lot of times, and they don't have damage provisions in them, and they don't have the deposits are usually not significant.
Yeah.
And so we can send over those things, but if y'all don't be afraid to ask for a 30-minute conversation for us to review it with you.
And to that point, I got to go, but my card, his card, both out there. Don't be strangers. I will be back next month. Cole, thank y'all. Thank y'all. Sorry, we're going to get this little, our gizmos working. I promise you. Bye, y'all. Thank you.
Another thing that so if you go after the new order process, right, I have contract drafting in here, and that goes a lot into what we just talked about. But from a contract drafting standpoint, I've seen, and this kind of applies to in the intake new order process for us, when we get a contract and it doesn't specify anything other than the municipal address on a contract. What that does for a title company is they go to the assessor's record and they look at that address, and the assessor is going to give you a brief legal description on there. So we've been getting a lot of contracts that say as per title. And the consequences of that is that your title company is going to look at that municipal address on the assessor's website, and they're going to assume that what that brief legal is what you're intending to transfer, because you did not specify one way or the other, right? And so I did a deal the other day where the municipal address was made up of lot 2 and 3. Well, lot 2 and 3 were two totally separate lots. One had a building pad on it, one had a house on it, but the contract said as per title. I've never been out to the property. I look at the assessor's record. That municipal address has 2 lots associated with it. The listing agent happened to be the daughter of the seller, so she knew that and still didn't amend the contract, left it at as per title. We closed on the deal selling lot 2 and 3, and the buyer acquired lot 2 and 3. And now the buyer, as an opportunistic person, is thinking, contract said as per title, municipal address was on there. Y'all came to closing. Everybody got the documents to review 3 or 4 days before. Nobody threw any red flags up about it. And so now we're having to try to unwind that, and that buyer's not playing ball. And so use the assessor's website to get that brief legal description. And if you wanted somebody to show you how to do that, it's very simple. Just go to the assessor's website, go to the search menu, type in the municipal address. The assessment's going to come back, and it's going to show you this section, township, and range, this much property, and it's going to give you a description, or it's going to say this subdivision, this lot, and this lot. So it'll give you some information on that. And if you want me to explain that to you or show you where to find it, and that's in every parish, not just St. Tammany. You can find that information. I can show you how to find it. Also, if you have a survey, include that with your information, because that makes a huge difference whenever we're running title to make sure that there's rights of way involved, like there's actual access to property and things like that, and it helps us identify the properties, and we can kind of see if there's any boundary issues we got to know about. I did a deal the other day where there was no access to this landlocked property in the record, and most people would overlook the fact that the survey that was recorded that showed all the lots and showed this piece of property we were selling had a right-of-way written on the survey, had it drawn up on the survey, and that survey was signed by all the people that own property between the landlocked property and the road. And a servitude by destination is one that is signed, a survey that is signed by all the parties can grant legal access to a piece of property. So we had legal access, but they just didn't realize it, and it took us a minute to find it, but the parties had a survey that wasn't recorded yet, and if we would have received that, we would have been able to, save us a little bit of headache on that end. So surveys make a huge difference.
Is there a specific type of mortgage that requires a survey?
No, there's no, usually if you're doing a construction loan, but most of the time your mortgages aren't going to need a survey. They're going to need right of access, though. You're never going to be able to finance a property without access. And not only access, the one problem with the survey that was signed by the parties with the right-of-way, it didn't talk about maintenance. So when you're financing with an end buyer, and usually it's FHA, those government-backed loans, they want to see, to give you the full story, they're assessing debt-to-income ratios for the end buyer, right? Part of the expenses, the debts associated with that borrower is the fact they have to pay to maintain a road. So if the road maintenance agreement doesn't specify that's going to be split between the 6 property owners that use the road, the lender's going to assume they have to pay for the whole thing, and they're going to put that on their debt-to-income ratio, which may not qualify somebody to buy the property. So surveys no, access yes, maintenance a lot of times on a finance deal is going to be required too. For me to close on a deal, I just need access from a title standpoint. Yeah. For you to finance it, the lender's going to want want maintenance. And something else about access when we're talking about that a little bit. I have a pet peeve about not just doing what people think they need and kind of going a step farther. Like we did a deal the other day where there was a 15-foot road that was accessing this property, and there was no road maintenance agreement or right-of-way that was in the record, so we were putting one together. And the people who own the properties between the road and this piece of property were like, oh, we're not going to give you any more than 15 feet. So the guy was like, oh, great, I get access to my property, 15 feet. This is a vacant piece of property he was buying. Well, if you think, I had this light bulb go off in my head, and I guess it's not really that much of it's not that difficult to come to this conclusion. You need to ask them what they're going to do with the property after they buy it. Well, they said they were going to put their primary residence on that. So I called Parish Planning, and they were like, you have to have a 35-foot driveway to get to your road. So we could have had them buy the property, because legally all you need is access, right? It could be you walking on, it could be walking access, but he wasn't going to be able to build his primary residence on that. So it's important to know what your people are going to do with it at the end and ask all the right questions so they don't get in a bind after they purchase this and can't do what they want with it. All right, I have another slide in here called seller financing provisions, and this goes back into the drafting of contracts. So you can use the Louisiana buy-sell agreement for a subject-to deal. And I encourage people to do that a lot of times. In the financing section of that buy-sell agreement, you can check the owner finance box. And then in the additional terms and conditions section, you can specify the terms of the owner financing. So you can put whether it's going to be a bond for deed or a credit sale, which we talked about that last time we were here. We talked a lot about seller financing. You can talk about whether there's going to be a balloon payment. You can talk about the terms of the subject-to financing and all that type of stuff in the other terms and conditions. So it's important to make sure that you include all that information in your contract, so the title company doesn't have, because if you get a contract signed and you don't put all those terms in there, and then we go to try to call y'all and figure out what the terms are, they'll haven't fully agreed to anything, and so if y'all can't come to terms with that, then technically y'all don't have a agreement to buy and sell a piece of property. So we need to know all those terms, and putting all of that in the other terms and conditions section is important. And when John's talking about helping you guys with contracts, like, we'll give you a form for a cash sale, we'll give you a form with a finance purchase, we'll give you a form for a seller finance deal, we'll give you one that's seller finance subject to, and we'll give you all different versions of these documents so that when you get these things signed, you can get it back. So tying all this together, we want all the right information up front, whether it's the description of the property, whether it's the seller financing terms. Getting all that right up front is going to help the title companies out immensely whenever they're drafting your agreement. So we don't have to come back and call and go back and forth with parties to figure out what they actually agree to. It's all in the document when we get it, so we can open the file and run with it. Does that make sense?
Do you have a document resource on your website?
It's a good idea.
These,
It's a good idea. You just have to have, like, being a lawyer, you have to have it all disclaimed up that this is, you should read with an attorney.
You can have like a login access.
Yeah.
Put a disclaimer, so.
$1,000 a month to access our form database.
I mean, I was thinking free access.
For sure. Everybody know the difference between a bond for deed and a credit sale?
Pretend we don't.
All right.
Credit sale is credit sale, and bond for deed is based on, we still, just like a car loan.
So the main difference between a bond for deed and a credit sale is when title transfers. Right? They're both seller. Yeah, I see what you're saying about the car loan, because the title stays with the lender. In a bond for deed scenario, the seller retains ownership in that property until the price is paid. So if I agree to sell my property to Cole for $100,000, he gives me $20,000 down. On a bond for deed scenario, I keep the title to the property until he pays me that $80,000 back. And we can break that down into principal and interest monthly payments, interest-only payments, with a balloon, however we want to structure that. But on a bond for deed, control of the property stays with the seller until I'm paid off. A credit sale is the because you got it.
So for bond for deed, if there's a loan there, can you do the wraparound mortgage for sale?
You can do a wraparound mortgage on that. Are you talking about buying it subject to the seller's mortgage, or then subject to it again?
If I sell property using bond for deed, and I still have a loan there?
They're very complicated, and they're less complicated if the seller owns the property free and clear. If the buyer buys it subject to and then sells it again, now you're wrapping a subject to deal, and there's just a ton of moving parts to that you got to be very sophisticated in the right situation in order to do that. But if the seller owns it free and clear, I sell the property to Cole, he can then wrap that transaction and sell it to somebody else on seller financing terms.
A bond for deed, but not a credit sale.
We recommend, if you're going to do that type of wrap, that you do a credit sale and then Cole bond for deed to somebody else. So I'll take a step back. A credit sale is the opposite of bond for deed. I sell my property to Cole, and then he signs a note and mortgage in my favor. So he gives me $20,000. I give him the title to my property, and he signs a note and mortgage in my favor, and I hold those documents until he pays me off. But he owns that property on the day of closing. Okay. So if I credit sale my property to Cole, he gives me $20,000. He's paying me $80,000 over time. Then he sells it to you for $150,000. You give him $50,000 down. You pay him $100,000 over time. You can do that. I wouldn't suggest doing a credit sale to a credit sale because you can't. He doesn't own it. He can't sell you the property at that point. But you can do credit sale to bond for deed.
And you can do a bond for deed as well?
Technically,
Yeah.
it's great. Like that's that. It's just the moving parts to that is, especially if it's subject to the authority that we grant to the buyer, the first buyer, with the loan staying in place. It's hard for you then, as the bond for deed seller, to turn around and give those same authorities to your bond for deed buyer, because you technically don't have the authority to pass my authority to them. You know what I'm saying? And then the insurance gets crazy because the mortgage company has to stay insured on that. So you have to have me insured, you insured, and that person insured under this insurance policy. And you already know the due on sale clause is a huge issue when it comes to those types of things. So you're tipping off the mortgage company when you add 17 people as insured on that. So it just gets complicated. I mean, it's done. We've done it. We've done it a couple of times, but it's complicated.
Is there a difference in it being foreclosure or like eviction with credit sales and bond for deed? Or are they both?
Yeah. On a bond for deed, since title stays with the seller, if you default, then my remedy is to send you a notice that you're late, or you don't have insurance, or whatever provision you breached of the bond for deed. I have to give you 45 days to cure that defect. If you don't cure the defect in 45 days, I can go to the clerk's office and cancel the bond for deed. I still own it. On a credit sale, since I've given you the property and I am a creditor, I'm a lien holder, I can ask the sheriff to seize the property, sell it at foreclosure auction, and then I get paid from that sale. So in a credit sale scenario, I'm not going to get the property back more than likely. On a bond for deed, I keep the property and I can go do it again. So usually it's beneficial for the seller to do a bond for deed, and it's beneficial for the buyer to do a credit sale. Another reason why it's beneficial for the buyer to do a credit sale, if I'm at the end of my investing career, I don't want to manage properties anymore, but I do want to sell or finance it to somebody, and I do a bond for deed, right? I'm a 90-year-old man. I bond for deed my property to you, and I die a month after we do our transaction. Now, while that is a heritable obligation on my children, they have to honor the terms of the bond for deed. They collect the money every month, and then if you pay them off, then they have to sell you the property. But I might have kids in 4 different places across the world. Now you have to go chase all of them down, help them understand what a bond for deed is, so they know they have to give you the property, and then come and actually sell you the property. And so it just gets complicated.
Would there have to be a succession done?
Oh yeah, succession too, for sure.
So, if you're the seller and your objective is to sell with seller financing of some sort, and your intention is to turn around and sell that note, would a credit sale then make more sense as you the seller, or would bond for deed still work?
I think you could sell the rights under a bond for deed to anybody. They would just have to honor those agreements too. But a credit sale makes more sense, just buying the note and the mortgage and the lien position. I mean, that's what every bank does on a traditional first mortgage. You have the right to do that too, unless it's specifically excluded in the note and mortgage. But I mean, you could definitely do it under a bond for deed. I haven't seen that. It's way more common to do a note and mortgage.
Okay.
And then, so discussing escrow and insurance on a seller finance deal. Again, we're tying this all back to making sure your contracts are written well, so that when your title company gets the contracts, it's very specific, right? If you just put seller finance in the financing section, you don't determine whether it's bond for deed or credit sale, your title company has to have those conversations, and that can kill a deal, right? So making sure you know that up front. When it comes to insurance, though, the general rule is that under a credit sale, because the title transfers to the buyer needs to be the one that gets the insurance policy, names the seller as an insured, and the mortgage company as additional insured. If it's a bond for deed, the title stays with the seller has the insurance policy, names the lender as the additional insured if it's subject to, and then the buyer as an additional insured as well. So you make sure that's written into your contracts, that the buyer agrees to have an insurance policy in their name with the seller as an additional insured on there. Okay? And then the last thing, are you going to have an escrow company that's going to be involved in collecting the monthly payments every month? Talk about that before you come to get the contract written. Even decide who it's going to be. Make sure you tell your buyer that they're going to have to pay a $400 setup fee. Every month they're going to pay $45 to $50 a month to the escrow servicing company. Have all those conversations up front so that we're not shocked at the end of the day when there's a $400 fee, and then 2 months in, the buyer has $45 they're paying a month that they didn't think they were going to pay. Because trust me, I get the calls all the time from people saying, nobody told me I'm paying them $45 a month. Like, well, that's not my fee. It's going to escrow services. That's their fee. That's what you have to do in order to do these seller finance deals.
Is that what current fees are, $45 a month?
Escrow services is a $350 on a credit sale, $400 on a bond for deed is a setup fee, and then it's like $45 a month for one and $50 a month for the other. Arena escrow exists, and we are this close. John got his background check done today so that we can start servicing credit sales and bond for deeds. So we are very close to being able to do that, and we plan on making that way more efficient than it is with the current resources that we have out there for escrow services. We're going to make it so much more streamlined for everybody and more transparent. So that's coming soon. So y'all be on the lookout for that if y'all are interested in those services.
Will you be doing that just for your in-house clients?
For anybody. If you think about it, from our standpoint, every time somebody goes to pay off their bond for deed or their credit sale, we have an easy access to new leads. If somebody needs an eviction or a cancellation, our law firm can handle that work. I mean, it's a lead source for us. It's a database for us to be gathered. So I'm not just being transparent. And then we build relationships with more people like you guys that we can do more of these types of deals with. So it is definitely a lead generator for us, because you don't. I told you what the numbers are. It's $45 a month. You know how many you have to do to make a living on $45 a month? Yeah, a lot of them. But it's all the ancillary work, and we already have all these processes and the team that can handle it. So we're just going to build a system around it, have one of our current admin do it, and just try to see if we can make that system. Have y'all dealt with any of the escrow companies around here on bond for deeds and credit sale? Yeah, I mean, you know, there's just not a lot of options, and they do a good job, but it's very much like picking up the phone and getting a receptionist and waiting on the phone to try to get somebody to answer your questions, and it's just not, it has not been updated to the current technology standards that we have now, and we're going to try to do that. All right, so next thing, dealing with title issues. So I have a list of title issues that I was going to run through here. I don't know how much time I have. 7:50.
Yeah, good for 20 more minutes.
Okay. I have a whole list of title issues that we can run through, but a lot of these things you can find ahead of time if you do a proper pre-screen. But when we get to closing and we find these types of things, the company that I was talking about earlier today, Kodiak Investments, that does a ton of real estate transactions, that we will communicate with them, and they will work with us to solve these problems. And so if y'all are looking for deal flow, they have a lot of deals going, and so there's definitely people to reach out to. Just throwing that out there. How many people are in buyers in the room? Okay. If y'all are interested in getting connected with them, the way they pump out deals is impressive. Yeah, they do a pretty good job. Sam and Scott. So if somebody has gone through bankruptcy, that's a question you should be asking on the front end. The reason why, if they have gone through bankruptcy or are currently going through bankruptcy, they have to get permission in order to sell the property. They can't just sell it. If they're going through bankruptcy, they have to have a bankruptcy trustee assigned to them. The bankruptcy trustee has to review the file, and they have to give approval on sale. And a lot of times you have to go to a hearing in order to do that. It takes time. It's crazy how many times we'll be, a week into the process and like, I got to go to the bankruptcy hearing tomorrow. We're like, pause. We got that. That makes a huge difference in what our process, and in order to be able to close. So it's important to know that if you're dealing with somebody who's in a distressed situation, have you filed bankruptcy? Have you thought about filing bankruptcy? Are you going to file it? Because we need to know that ahead of time. I think Courtney would tell you. I mean, she has these direct conversations. If we're going to do this deal, you have to be upfront with me. Are you currently going through a divorce? Are you thinking about getting divorced? Are you thinking about filing bankruptcy? Have you filed bankruptcy? She asks those direct questions because she knows that can throw a huge wrench in her plans if she doesn't. And so she's built that into her system so that she doesn't have that problem going forward. If somebody has judgments, a lot of times they don't want to admit it. I'm dealing with a guy right now that has $1 million property, and there is $1 million, $1.2 million worth of liens. He's upside down. He's got sued by family, and he's got to deal with payoffs and all these different things. If I know about them up front, I can work with them to get those things resolved. So just to go down another little rabbit hole here, the difference between a general mortgage inscription and a specific mortgage inscription, okay? Specific mortgage inscription is something that burdens one specific piece of property, okay? So if I have a mortgage on my primary residence, I have a note and a mortgage, and that mortgage states that this particular property is mortgaged, right? So that is specific. That mortgage company can only have access to that one piece of property if they have to foreclose. So that's a specific mortgage inscription. A general inscription is something that attaches to every property that you own in the parish in which that mortgage is filed. Okay? A judgment that you get against your name attaches to every property that you own in the parish, and whatever parish that judgment's filed. So that's a good and a bad thing, right? If you have a state tax lien, that's a general mortgage inscription. If you have a judgment, that's a general mortgage inscription. It attaches to everything. If I see that on the file, right? So this file I have is a $500,000 first mortgage and $700,000 worth of judgments. The benefit of a judgment attaching to all the property somebody owns, if I have 4 properties and I have a judgment that's worth $700,000, but there's only $300,000 in equity in this property I'm selling. A lot of times you can go to that lien holder and say, look, we'll give you $300,000 to get a partial release on this property that we're selling so that we can sell it. You can pay down that debt that you're owed, and you still have 3 other pieces of property to use as collateral. But if I don't know that type of thing, it causes a delay in the closing process if I can't call and have those conversations up front and ahead of time. So in this scenario with this guy that has this $1.2 million property and a $1 million property, 1.2 in liens, there is a $700,000 worth of judgments. I can start picking those judgments apart and figuring out who's willing to negotiate to accept some money, because otherwise I'm not going to get anything, to release this property so that the buyer can buy, so the seller can move on, and this person can get at least a portion of what they're owed. So judgments are important that you have those conversations up front, and a pre-screen will help with that, and we can solve problems faster if we know about them ahead of time. We talked about forbearance already. Ask the question. Do you only have one mortgage on the property? Do you have any other liens? Yes or no? If they say no, ask the question. Did you have to apply for your bank for any type of assistance during COVID or for any other heartaches you were having? If they say yes, then you go push harder and find out if the bank delayed payments for them for a little while, because those things are important. That's how you can find out if there's a forbearance. Succession property, if it's asking where the person who owned the property lived when they passed away, because if this property's in Tangi but they died in St. Tammany, their succession could be in St. Tammany Parish and recorded, just not recorded in Tangi. And we'll think we have to do a full succession for this person because you didn't tell me that they died one parish over, where I could go run to that record and pull that succession and file it over here, and now we've not had to go through the whole succession process. So find out where the person died if you're dealing with succession property and tell the title company. Undisclosed co-owners. We can do partitions on properties. We do it often, where two people inherit. I'm dealing with this right now. 2 people inherited. One wants to sell. The other doesn't want to sell. In the state of Louisiana, one co-owner cannot force the other one to own property. This one can't say, I want to sell, and this one say, no, I'm not selling, so now the other one has to stay. This person can force the other person to sell. And so we can do a lot of that for people. We're dealing with one of those or a couple of those right now. Road access, we talked about that. I have foreclosure on here, which that horse has been beaten, I think, in these kind of conversations. Inspection issues. Y'all don't do a ton of inspections on y'all's deals, right? Due diligence? You do? You have any issues with due diligence? No? I mean, negotiating those things and making sure you're meeting your due diligence periods and all that is important. Yeah. Knowing the difference between a power of attorney and a certificate of authority. Powers of attorney apply for individual people. Certificates of authority deal with businesses. So in order for somebody to be able to represent a business, they have to have authority through a certificate of authority. In order for somebody to be able to represent an individual, they have to have a power of attorney. The big consequential difference between that is that if the property is owned by a business, the COA can be signed electronically. It doesn't have to be notarized. POA does have to be notarized. And we've dealt with people that live in other countries having to get powers of attorney drafted up. They're going to embassies and driving and flying different places. It can just be chaotic and hard to communicate because they're on different time zones. And so knowing whether those things are in place, or if you have a client who may go offshore, getting those types of documents put in place ahead of time, asking those questions like, what's your job? Are you going to be out of the country anytime soon? Do we need to get these documents prepped early? We'll do those things ahead of time, and not charge people until we get to closing, just so we can know that we have documents in place. Wire versus certified funds versus personal checks. So if you're having a conversation with your client about bringing money to closing, if it's $2,500 or less, it can be a personal check. $25,000 or more, it's got to be a certified check. And we can accept a wire in both scenarios. And wires are usually the safest bet, but make sure, I'm going to tell you 2 nightmare scenarios so you don't.
Did you say $2,500?
$2,500. $2,500. And that's not us, that's a rule that our underwriters put on all title companies. So, if we accept a $3,000 check, I'm okay with if something happens and goes sideways, I have to pay $500 to fix that problem. A $250,000 check, I'm not going to accept the personal check. If that bounces, then I'm going to be out $250,000. My underwriter's not going to have my back on that. I should not have accepted that. Two nightmare scenarios. Make sure when you're dealing with your clients about a wire that if they're going to accept wiring instructions from somebody, that they pick up the phone and call that person and verify that the instructions are correct. I'll tell you why. My client lost $150,000 and they're not going to get it back. Their client was going to wire money to us. We sent the wiring instructions to that client, okay? That client had a Gmail account that was hacked by somebody who was watching their email account. They intercepted our wiring instructions into that person, changed our email address by one decimal point, or one period in between Arena and Collective, and then changed the wiring instructions, acted like us, sent them to the borrower sent them to the bank. The bank wired money based on the instructions that the borrower sent to them, wired it to a fraudulent account, money's gone. That bank should have called us. They called the client. Hey, will you verify the instructions? Well, that person received fraudulent instructions from not us, and so when they called them, they read them and they were accurate. Instead of calling the person that is going to be receiving the money, not the person who sent you the instructions. So a lot of times the title company will send, I tell everybody, connect me with your banker so I can send it straight to them, and I can have a conversation with your banker, and you don't have to play middleman, and we know the money's not going to get lost. But it's super important that if you're going to accept wiring instructions and you don't have a secure account, that you make sure that you call that person on the phone and verify the instructions on the phone with them. Because once the money's gone, it's gone. Most of the time, that when that money goes into somebody's account that's fraudulent, that's not the real mastermind behind this, right? The real mastermind is somewhere else across the world. This is just somebody they paid $100,000 to open an account up to go away. That account's in their name, just sitting there. That person has no idea what's going on with that account. That is exactly what happened. My boss overseas paid this person to set up an account, just said, don't ask any questions and go in, I'll give you this cash. The guy went away. So the FBI didn't arrest the guy who had the fraudulent account. He's not the guy they're after. They're after the guy who's actually scheming all this up. So a lot of times the money's gone and you don't get that back. Second thing, if somebody tries to give you a certified check in the mail, it is a fraudster. We have received $250,000 in the mail from an overseas bank account and a certified check 3 times. And I'm not going to call somebody a liar, so I take the money, I put it through my check scanner, the check scanner won't read it. Take it, send it to my bank, they actually run the check, because it's a certified check, they put the money in my account, and for the next 10 days, the FDIC is going to look at it. If the FDIC rejects that check over the next 10 days, then if I have cut another check relying on that, it's on me for not waiting that 10-day period. And I get charged every time I run a fraudulent check through the system $50 because for NSF fees. And so we do it anyway because we want to make sure. But it should be a huge red flag to people that if somebody wants to put a certified check in the mail, that it's not going to be real. And you think that that's a crazy scenario. We've had it happen 3 different times in the last year where people send us a check and it comes in, it's Bank of Nova Scotia, and it's not a real. And you call it and somebody answers the phone. Like there are people answering these phones. It's not like you're just assuming that we call people answer the phone, but it's not a real check. Okay? Make sure you do that. Different closing rooms, we do that all the time. Just let us know ahead of time. It's the craziest thing. We schedule these closings and people walk in the door and be like, hey, I don't want to be in the room with that person. It's like, well, just let me know ahead of time so we're not like putting you in the same room and then you walk in and you're mad at us because you're in the same room with somebody. But we know that sometimes there's opportunities for people to be in the same room. Y'all know what pass-through funding is? Pass-through funding is on a double close scenario where you as the wholesaler in the middle have a purchase agreement with the seller, and then you turn around and have another contract with an end buyer. So you have 2 different transactions, 2 different purchase agreements. Pass-through funding means that the end buyer transaction happens at the same time as the transaction between you and the seller, and we'll roll money from the first deal from the end buyer to the seller so that you don't have to bring money to the closing table. We will do that, but we try at our best to have the closings go on at the same time in case somebody decides to change their mind last minute. We haven't started moving money, so that is a possibility.
You wouldn't need transactional funding? That's not...
Transactional funding, from what I know, means that somebody is financing that one day for you to buy it and then sell it on the same day. But we roll the money through our system so you don't have to go and take money from
As long
somebody.
as it's the same time, exact same time.
We do it an hour apart sometimes, but I prefer one to be in one conference room and the other be in the other conference room, and we'll.
So for double closing in your company, as a wholesaler, we do not need to bring you money for transaction, just the buyer will do.
Yep, we like to do it at the same time to avoid any issues. We haven't seen a bunch of double closes. I mean, I try to push all my wholesalers to do assignments because it's the wholesaler makes more money. I mean, if you're going to be buying the property, we're going to charge you to open the file, not our full fee, like a big discount on it, but you're going to do that. You're going to have to pay to record the deed from when you acquired it, and you're going to get a 1099. Obviously, you and your CPA can work out how you can write all that off, but most of it off. But you got those fees, and then you got to turn around and sell it. We're going to charge you a little bit on the sell side, and so you're going to have to pay a fee if you're going to be doing a double close. On an assignment, you're just getting your assignment fee. There's no fees from on those transactions. So sometimes there's a reason why you want to do it, but I get that. Just knowing that assignments are a little more efficient is important. All right, that was the last slide that I have. I do want to say one more. Have y'all seen any subject to deals lately? Y'all know what that is? Subject to financing. Have y'all seen a lot of that? Been offered a lot of that? Or have y'all done any deals like that?
Seen lots on Facebook groups and stuff like that lately, yeah.
Yeah, we're doing a lot of them. I mean, we're doing a couple of them a month. They were a little bit more prevalent earlier this year, and they slowed down a lot. The biggest, who doesn't understand what a subject to deal is? All right. So a subject to deal means that the seller's mortgage is going to remain in place, and so two relationships are created at closing, or two relationships that are formed at closing. So the first relationship is between the seller and the lender, right? When that person bought that property, they signed a note mortgage saying that I'm going to pay you over time. The second relationship that's formed is the relationship between the buyer and the seller, where that buyer says to seller, I am going to pay your mortgage for you. There's no direct relationship between the buyer and the lender. It's not an assumption of the loan. So that seller credit's going to stay intact with that mortgage company until it's paid off, right? And so the biggest risk is the due on sale clause, meaning that if the lender found out that the seller had sold the property, bond for deed or credit sale, the lender has the right to call the loan due, and that end buyer has to either refinance, sell, or pay off the property with cash. And so a lot of times we have a lot of disclosures in our closing documents that say buyer and seller acknowledge that the loan's not going to be paid off, buyer and seller acknowledge that the bank could call the loan due, buyer and seller acknowledge that the buyer's not going to call the mortgage company and tell them that they did this because that's going to sabotage the deal. Well, we dealt with one the other day where the buyer did not call the mortgage company. The buyer had government assistance with a local government assistance program out of New Orleans. They called that company and said, I no longer need the assistance. That company called the mortgage company to tell them that they didn't need assistance anymore. That triggered the mortgage company to call the seller to ask him what happened. The seller told them that they sold. Now that bank's calling the loan due, and that investor's going to have to either refinance, sell, or pay cash to pay that property off. So just another thing we learned on subject to deals that we weren't really considering before, that you as an investor need to know that if you're going to a seller and they have government assistance and you're trying to buy a subject to, there may not be a great property to subject to because of the fact that there's government assistance there.
Say, Jared, you just said that the seller was on some sort of government assistance, is that what you said?
Yeah, the government assistance program was subsidizing a portion of their mortgage payment.
Oh, okay.
And because the mortgage payment, they didn't need it anymore, and the buyer honestly said, I don't want to take advantage of this situation. Like, I don't need the government assistance. I'll rent this property out. We can cancel that. And that company told the mortgage company, and the mortgage company called, and the mortgage company is now. This is the first time I've seen the due on sale clause triggered by a mortgage company doing a subject to deal this year. So just something to think about whenever you're meeting with your sellers on that kind of stuff.
So talking about subject to, if the seller sells his house using bond for deed, will that still trigger the due on sale clause?
Yeah, so it's what's called an equitable interest. And so when an equitable interest in the property is transferred, then that due on sale clause is triggered. A lot of people were using the bond for deed strategy as a way to circumvent the due on sale clause. Well, then mortgage companies built into the their provision that says a sale or an equitable interest transfer triggers a due on sale clause. So it now applies.
Can you talk more about like a damage provision in a contract I was talking about earlier? What's the damage there?
Yeah, I mean, I always go back to the Louisiana buy-sell agreement because it is a 8-page document, but I think it's the most inclusive way for you to write a contract and everything's in there. A lot of investors will tell me, I don't want to use that because it's too long. I don't want to over-explain, or I don't want to overburden a seller in this scenario. I just want a simple one-page contract. So a simple one-page contract is simple, but it doesn't usually cover all the details. And something I always see left out is a damages provision, which would hold somebody accountable for breaching the contract. If the contract doesn't have any consequence for somebody to back out of it, the only way you can really enforce it is to sue them and try to have a judge sue for or force them to perform under the contract. You can't ask for damages usually because it's not stipulated in that you're entitled to them if they breach the contract. So in the Louisiana buy-sell agreement, if the buyer or the seller breaches the contract, then the other party is entitled to 10% damages based on the purchase price. So if the property's $100,000 and the buyer breaches the contract, the seller can sue them for $10,000, $200,000, $20,000, $300,000, $30,000. Say it again?
It's not physical damage.
No, just damages for them. It's like me. It would be me saying that if I decide to back out of this last minute, I'm going to give you 10% of the purchase price for doing that. You don't have to prove the damage at that point. You're stating in that agreement that I'm willing to give you that if I decide outside of due diligence to back out. Yeah. So it's important to have that, and a lot of wholesalers don't have those provisions in their contract, so they can't hold somebody accountable. And so if you have an assignment contract, and then it usually doesn't happen where the wholesaler or the seller wants to breach the contract. It's usually the end buyer that decides to run or breach the contract. So if you understand the dynamics of it, you have a contract with the seller, and then you either assign that to an end buyer or you sign another contract with an end buyer. So you're on the hook to buy that property. You're not passing that obligation on to the end buyer. You're just bringing them into the transaction and saying, hey, you're gonna buy this, and if you don't, I'm still gonna be on the hook for it. So that end buyer runs away, and you don't have any teeth in the contract between you and the end buyer. You're on the hook to buy it from the seller, and there's nothing you can do to get that person to come back. You're obligated to buy that property from the seller. And so that's I've seen that a lot of times where wholesalers and investors get in trouble because they don't make the end buyer have signed any damages provisions in their contracts, and then now they're obligated to buy from the seller. It happened the other day on a deal where with a big wholesale company, they were able to find a new end buyer and avoided an issue. But they were like, "Can we sue that person?" I'm like, "Your contract has no consequence for them." So it's important to have that in there. Anybody else?
So you talk about the judgment. So in Louisiana, how long the judgment will be valid?
So 10 years. So if I have a judgment against me, after 10 years, that judgment no longer has any effect. However, the creditor can reinscribe that for another 10 years. So if a judgment this is actually revived as a judgment. So if you, before the 10-year mark, revive a judgment, it lasts for another 10 years. And you can keep doing that indefinitely until they pay you off.
How about child support?
Same. Well, I don't think child support has a 10-year prescription period. I'd have to check on that. I have to make sure. But we deal with child support every once in a while, and those usually are a little more sticky than a traditional judgment. I have to find out. I can give you that answer, though, if you are interested.